Welcome to this practice review of the Virginia Real Estate Salesperson exam. Each question breaks down the right answer, why the distractors failed, and the core concept behind it. Today's a full mixed practice set, spanning land use and ownership, agency duties and representation, purchase agreements and remedies, mortgages and valuation, state regulation and licensing. Don't forget, our website has free practice questions and study guides to help you truly master this exam. Everything you need is right there, just a click away, with the link waiting in the description below. So go ahead, study smarter instead of harder, and start your journey today. Okay, let's begin. Question 1. A seller in Chesterfield County installed a chandelier in the dining room by wiring it into the ceiling box and now wants to take it when she moves. The buyer objects that it belongs to the house. Which of the following determines the outcome? Your options are A. The original purchase price of the item. B. Whether the seller installed it personally. C. Whether the item has become a fixture. D. The length of time it was installed. Which one is it? Pause the video if you need more time. The correct answer is C. Whether the item has become a fixture. C is correct because once personal property is attached so that it becomes part of the real estate, it is a fixture and passes with the house unless the contract says otherwise. Method of annexation, adaptation, and intent decide the question. A is wrong because cost tells a buyer how much is at stake and says nothing about whether the item became part of the building. An inexpensive fixture still conveys, and an expensive lamp on a hook does not. B is wrong because who did the work is beside the point. A homeowner, an electrician, or a previous owner could have installed the same chandelier with the same legal result for the buyer. D is wrong because duration matters only as weak evidence of intent. An item hardwired in last month is a fixture, while a freestanding lamp plugged in for 20 years never becomes one. Real property and personal property travel by different means, but some items cross from one category into the other. Those items are called fixtures, and figuring out where they belong decides who owns them at settlement. Courts resolve fixture disputes with 3 factors. Annexation asks how firmly the item is fastened and what removal would leave behind. Adaptation asks whether it was fitted specifically to this building. Intent asks what the installer appeared to intend, and it carries the most weight of the 3. Picture a chandelier hardwired into a ceiling box, bolted to a joist, versus a lamp simply plugged into an outlet. The wired connection leaves damage if removed and sits squarely on the real property side of the line, while the plug leaves nothing behind. Intent sounds like a private state of mind, but it isn't. The law infers intent from annexation and adaptation, which is why those 2 are treated as proof rather than separate tests. Cost, who installed it, and how long it's been, there are tempting but false leads on an exam. Trade fixtures and agricultural fixtures run the opposite direction, staying personal property because of the tenant's clear intent, but in practice, a contract that simply lists an item as included or excluded avoids the whole argument before it starts. Question 2. A buyer submits an offer on a house in Fredericksburg along with a deposit intended to show that she means to follow through. Her agent is asked whether the offer would be invalid without that money. Which of the following is correct? Your options are A. Deposit is customary rather than legally required. B. The deposit supplies the contract's consideration. C. No offer without a deposit. D. Deposit converts the offer into an option. Take a second. Which answer would you pick? The correct answer is A. Deposit is customary rather than legally required. A is correct because earnest money demonstrates good faith and gives the seller a fund to look to on default, but the promises the parties exchange supply the consideration. A contract can form without any deposit at all. B is wrong because consideration in a purchase contract is the exchange of promises, with the buyer promising to pay and the seller promising to convey. The deposit is security rather than the thing that makes the bargain binding. C is wrong because a licensee must present every written offer to her client promptly, whether or not money accompanies it. Refusing to transmit an offer over a missing deposit would itself be a violation. D is wrong because an option gives the buyer the right to purchase without any obligation. Purchase for separate consideration. This buyer has committed to purchase, which is a fundamentally different arrangement. Almost everyone believes a purchase contract needs earnest money to be binding. That belief is custom, not law, and it survives simply because a deposit shows up in nearly every deal. A real estate contract binds when the essential elements line up: competent parties, mutual assent, a lawful purpose and description, and consideration backed by a signed writing. A deposit appears nowhere on that list. Consideration is simply the bargained for exchange that makes a promise enforceable. In a purchase contract, the buyer's promise to pay and the seller's promise to convey title are each other's price, and that exchange completes the consideration on its own. Earnest money still does real work, it just isn't structural. It signals that a buyer is serious, gives the seller a fund to draw on if the buyer defaults, and a larger deposit can make an offer look stronger. Remove it and the contract still stands. The option contract is where the intuition finally becomes true. There, money paid to hold an offer open genuinely is the consideration, because the optionee gets the right to buy with no obligation to do so. In a bilateral purchase contract, though, the promises already did that job, and the deposit just rides alongside them as security. Question 3. A licensee in Norfolk representing a seller is asked by an unrepresented buyer to explain what a particular contingency in the offer would mean if the appraisal came in low. Which of the following describes the licensee's position? Your options are: the explanation is a routine ministerial act. B. Explain the clause to any customer. Sir, she may explain it after disclosing representation. D. Interpreting the clause exceeds a ministerial act. Before I reveal it, which one do you think is right? The correct answer is D. Interpreting the clause exceeds a ministerial act. D is correct because ministerial acts are routine acts that do not involve discretion or the exercise of the licensee's own judgment. Interpreting a contingency calls for exactly that judgment and falls outside the category. A is wrong because routine describes unlocking a door, arranging an appointment, or handing over a pre-printed form. Advising someone what a contract term will do to his position is a different order of activity. B is wrong because a customer receives honesty, disclosure of known adverse physical facts, and written disclosure of whom the licensee represents. Contract advice is not on that short list, and the rule was written to prevent exactly that. C is wrong because disclosure of the brokerage relationship is separately required and does not enlarge what the licensee may do. Telling the buyer she works for the seller makes the advice more troubling, not less. Licensees deal with non-clients all day long, and Virginia law needed a way to let them help without accidentally creating an agency relationship. The answer is a category called the Ministerial Act. A ministerial act is routine, informative, or clerical, and it never involves the licensee's own discretion. Opening a house, scheduling an appointment, handing over a form, or quoting square footage all fit, because the licensee is only moving information or logistics, not shaping anyone's position. The line the term draws is between a client and a customer. A client gets the full package: loyalty, confidentiality, accounting, and advice on what contract terms mean. A customer gets only honesty, disclosure of known adverse facts, and written disclosure of who the licensee represents. Interpreting a contingency is the classic step across the line. Pointing to where a clause appears in the document is fact. Explaining what a low appraisal would do to that buyer's own position is judgment. And judgment is exactly what the definition excludes. Disclosing who you represent doesn't fix the problem. It just describes the relationship. It doesn't expand what you're allowed to do. The safe move costs nothing. Point to the clause, disclose your role, and send the buyer to his own licensee or attorney. Question 4. An investor screening small rental houses in Richmond compares each property's asking price against its monthly gross rent to get a rough sense of relative value. The point is worth settling before anything else moves forward. Which of the following describes the figure she is using? Your options are A. A capitalization rate, B. A gross rent multiplier, C. An equity dividend rate, D. An operating expense ratio. What's your answer? Commit to one before I continue. The correct answer is B. A gross rent multiplier. B is correct because a gross rent multiplier relates price to gross rent without accounting for vacancy or expenses. It works as a quick screening tool for similar small properties and never substitutes for a full valuation. A is wrong because a capitalization rate uses net operating income after expenses and vacancy rather than gross rent. It supports an actual value estimate under the income approach, and the correct answer accounts for what this misses. C is wrong because an equity dividend rate measures the cash an investor receives against the cash she put in. It speaks to the return on an investment already made rather than to comparative pricing. D is wrong because an operating expense ratio compares expenses with effective gross income and tests how efficiently a property runs. It says nothing about whether the asking price is reasonable, and the difference matters in practice. When an investor needs to sort a long list of properties into a short one without ordering appraisals, she reaches for a quick arithmetic filter, the gross rent multiplier. The multiplier is price divided by gross rent, and its defining feature is what the denominator has not been cleaned of. Nothing is subtracted for vacancy, collection loss, taxes, insurance, repairs, or management, so the result is a ratio, not a value, and it only means something compared against similar sales computed the same way. The gross rent multiplier is easily confused with three other tools. The capitalization rate uses net operating income to support an actual value estimate. The equity dividend rate measures cash-on-cash return on money already invested. The operating expense ratio tests how efficiently a property is run. The real difference between the multiplier and the cap rate is what survives before the division happens. Gross rent flows straight into the multiplier untouched, while net operating income has already been scrubbed of vacancy, collection loss, and expenses before it feeds the cap rate. The gross rent multiplier survives because it's fast, and that speed comes from ignoring information an investor eventually has to gather anyway. It sorts a long list into a short one, but it never replaces a full valuation. Question 5. A deed conveys a Loudoun County farm to a woman for the duration of her life, with the property going to her nephew when she dies. The nephew asks what interest each of them now holds. Which of the following is correct? Your options are A. Life estate with a remainder, B. A fee simple absolute in the woman, C. A leasehold estate with a reversion, D. Joint tenancy between the two of them. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. Life estate with a remainder. A is correct because the woman holds a life estate measured by her own life, and because the future interest was granted to a third party rather than kept by the grantor, the nephew holds a remainder. B is wrong because fee simple absolute is ownership of unlimited duration that passes to the owner's heirs. This deed cuts the woman's interest off at her death, which is the defining feature of a life estate. C is wrong because a leasehold gives a tenant possession for a stated term under a lease, and a reversion returns the property to the grantor rather than to a named third party. D is wrong because joint tenants own the same interest at the same time with equal rights of possession. Here the nephew has no present right to possess anything while the woman lives. A single deed can slice ownership across time instead of just handing it over once. One person gets possession now, another gets it later, and both slices are real estates that exist simultaneously. The life tenant genuinely owns the property for as long as she lives. She can occupy it, lease it, or sell her interest, but she can never convey more than she has, and she must pay taxes, keep up repairs, and avoid waste. Like clear-cutting timber that belongs to the next owner. The future interest turns on who receives the property when the measuring life ends. If it goes back to the grantor, that's a reversion. If it goes to a named third party, that's a remainder held by a remainderman. And if the measuring life belongs to someone other than the holder, the estate is called pure autre vie. Picture the farm itself split down a timeline. The aunt holds present possession, the nephew holds the future interest, and both pieces exist right now. Neither one alone equals full ownership. A buyer wanting clean title needs a deed from both of them. Both a reversion and a remainder wait for the same triggering event, the end of the measuring life. The only question that matters is where the property goes next, back to the grantor or forward to someone new. Question 6. The Virginia Real Estate Board learns that an unlicensed person has been marketing properties and collecting commissions in Petersburg. Which of the following describes the civil penalty the board may impose along with a cease and desist order? Your options are A. A flat statutory penalty. B. Twice the compensation the person received. C. $1,000 or the compensation. D. Restitution to consumers with no separate penalty. Which would you go with? Lock it in before the reveal. The correct answer is C. $1,000 or the compensation. C is correct because the board may order the conduct to stop and impose a civil penalty not exceeding $1,000 for any real estate transaction or the compensation received from that transaction, whichever is greater. A is wrong because the Administrative Process Act governs how boards conduct fact-finding and hearings. It supplies procedure rather than a penalty figure for unlicensed real estate activity, and the governing provision says otherwise. B is wrong because doubling the compensation would be a familiar remedy in some consumer statutes and is not what this section says. The statute compares $1,000 against the compensation and takes the larger. D is wrong because restitution addresses the consumer's loss and does not deter the conduct. The General Assembly gave the board a penalty precisely because unlicensed activity often leaves no traceable loss. Licensing tools like suspension and revocation only work on someone who holds a license. Point them at an unlicensed operator and every threat goes hollow because there's nothing to take away. That gap is exactly the problem cease and desist authority was built to close. The remedy has two parts, an order to stop plus a civil penalty measured per transaction. That penalty is the greater of $1,000 or the compensation earned. A flat cap alone is trivial against a big commission, and compensation alone fails when payment was cash or the deal collapsed. So taking the larger of the two closes both escape routes. 3 separate figures generate most of the confusion, but they split cleanly by target. The $1,000 measure targets people with no license at all. A higher per violation ceiling applies to licensees a board is disciplining. A third, larger figure belongs to civil actions the department itself pursues. Restitution feels intuitive but misses the point, because it only restores a quantifiable loss, and unlicensed activity often produces none. The property sold, the seller got paid, the buyer moved in. The real casualty is the regulatory scheme. No exam, no background check, no education, no oversight, no recovery fund protection. The Administrative Process Act supplies notice, hearings and appeal rights, but it never sets penalty figures. Those ceilings come from the licensing statutes themselves, and confusing the two is the exact mistake this distinction is designed to catch. Question 7. A borrower closing on a house in Roanoke signs 2 documents at settlement, one containing her promise to repay and one pledging the property as security for that promise. Which of the following identifies the instrument containing the promise? Your options are A. The deed of trust, B. The settlement statement, C. The certificate of satisfaction, D. The promissory note. Don't overthink it. Which one feels right? The correct answer is D. The promissory note. D is correct because the promissory note is the borrower's written promise to repay and is the evidence of the debt itself. The deed of trust is the separate security instrument that pledges the real estate. A is wrong because the deed of trust conveys bare legal title to a trustee and grants the power of sale on default. It secures the debt rather than creating the obligation to pay it. B is wrong because a settlement statement accounts for the money moving through the closing. It records what was paid to whom and creates no ongoing obligation between borrower and lender, and it overlooks the operative language. C is wrong because a certificate of satisfaction is recorded once the loan is paid off, releasing the lien. It marks the end of the relationship rather than the beginning, which the facts here do not support. Every residential closing in Roanoke turns on 2 documents that do the real legal work. One is a promise to repay, and the other is the security behind that promise. Keeping them straight is the key to almost every financing question you'll face. The promissory note is the evidence of debt, a complete obligation standing on its own. It sets the principal, rate, term, payment schedule, late charges, prepayment terms, and the acceleration clause, and it's signed only by the borrower and never recorded. Virginia uses a 3-party deed of trust instead of a 2-party mortgage. The borrower, or grantor, conveys bare legal title to a trustee, who holds it for the lender, the beneficiary, while the borrower keeps possession and equitable ownership, and the whole arrangement gets recorded to establish lien priority. The dependency runs one way only. A note can exist unsecured, but a deed of trust without a debt secures nothing and is void. That's why an assignment of the note automatically carries the deed of trust with it, and why paying off the note earns you a release, not the reverse. So watch the exam language. Promise to repay points to the note, pledging property and conveying title point to the deed of trust. Clearing the lien after payoff is the certificate of satisfaction, and an accounting of closing funds is the settlement statement. Promise, pledge, release and account. 4 documents, 4 jobs, no overlap. Question 8. The Virginia Department of Transportation needs a strip of a homeowner's front yard in Hanover County for a road widening and the owner refuses to sell. Which of the following describes the government power and the process involved? Your options are A. Police power exercised through zoning, B. Eminent domain exercised through condemnation, C. Escheat exercised through the circuit court, D. Taxation exercised through a special assessment. Got a guess? Lock it in. The correct answer is B. Eminent domain exercised through condemnation. B is correct because eminent domain is the government's power to take private property for public use, and condemnation is the legal proceeding through which it does so. Just compensation must be paid to the owner. A is wrong because police power regulates the use of land for health, safety and welfare and takes no title. A zoning restriction limits what an owner may build without paying her anything. C is wrong because escheat transfers property to the state when an owner dies with no heirs and no will. Nothing about a road project involves a deceased owner or a failure of succession. D is wrong because a special assessment charges nearby owners for a local improvement that benefits their property. It collects money rather than acquiring an interest in the land, and the governing provision says otherwise. Private land ownership in America has never been absolute. Every deed sits beneath 4 retained powers of the sovereign: police power, eminent domain, taxation, and escheat. Police power restricts use without paying. Eminent domain takes an interest in land and requires compensation. Taxation collects money secured by a lien. Escheat passes property to the state when an owner dies with no will and no heirs. Eminent domain is the authority itself, while condemnation is the legal proceeding that exercises it. A third term, inverse condemnation, is the lawsuit an owner brings when government effectively takes property, like flooding a parcel, without ever filing a condemnation case. In a partial taking, like a road widening, the government acquires only a strip of frontage, leaving the owner the residue behind it. Compensation covers the value of that strip plus any damages to the residue, such as a house now sitting closer to traffic. Acquisition with compensation is the fingerprint of eminent domain alone. Regulation without payment points to police power. A charge on benefited parcels points to taxation, and a deceased owner with no heirs points to escheat. Question 9. A purchase contract on a Williamsburg house is conditioned on the buyer obtaining financing on stated terms by a specific date. The buyer applies promptly but is denied. Which of the following describes the effect of that condition? Your options are: A. The seller may sue for specific performance. B. The contract was void from the beginning. C. The buyer may terminate under the contingency. D. The deposit is forfeited to the seller. Which one is it? Pause the video if you need more time. The correct answer is C. The buyer may terminate under the contingency. C is correct because a contingency makes performance conditional on a stated event. When the buyer pursues financing in good faith and the condition fails, she may terminate and recover her deposit under the contract's terms. A is wrong because specific performance compels a party who breached to complete the transaction. A buyer who invoked a bargain for contingency after acting in good faith has not breached anything, which is why the distinction is worth memorizing. B is wrong because a void contract never existed at all, which would leave neither party with rights. This agreement was fully valid and simply failed to reach performance because a stated condition was not met. D is wrong because forfeiture follows a default. Where the contract itself excuses performance on the failure of a contingency, the deposit returns to the buyer rather than to the seller, so it resolves nothing for these parties. When a contingency fails, that is not a breach. To understand why, you have to see that contract law treats conditions and promises as completely different creatures. A promise is a commitment, and breaking it exposes you to remedies. A condition is different. It's an event that must happen before any duty to perform even arises. When a condition fails, that duty never matured, so nobody breached anything. A financing contingency is a condition precedent written for the buyer's protection, and a well-drafted one is specific: loan type, maximum principal, a rate ceiling, a commitment deadline, and a requirement that the buyer apply promptly and pursue the loan diligently. Precision matters because a vague clause just invites argument. Keep 3 terms separate. A void contract never existed at all. A voidable contract exists and binds until the protected party avoids it. And a valid contract can still terminate on its own terms, which is exactly what happens when a financing condition fails. Since specific performance and forfeiture both presuppose a breach, a buyer who applied in good faith and was denied has no remedy pointed at her, and her deposit simply returns. The deal ends clean, not broken. Question 10. A seller in Danville signs an agreement under which her broker earns a commission no matter who finds the buyer, including the seller herself. Two similar sounding rules govern nearby situations here. Which of the following identifies that arrangement? Your options are A. An exclusive right to sell listing, B. An exclusive agency listing, C. An open listing, D. Our net listing. Take a second. Which answer would you pick? The correct answer is A. An exclusive right to sell listing. A is correct because an exclusive right to sell listing pays the broker regardless of who produces the buyer. An exclusive agency listing pays only if someone other than the owner finds the buyer. B is wrong because exclusive agency reserves the seller's right to sell without paying a commission. That single exception is what separates it from the arrangement described here, and the practical result would be quite different. C is wrong because an open listing lets the seller engage several brokers and pay only the one who produces the buyer. It offers the broker no protection at all and is rare in residential practice. D is wrong because a net listing lets the licensee keep everything above a figure the seller names. Virginia prohibits the arrangement by regulation because it puts the licensee's interest against the client's. A listing agreement is a contract for services, and the broker's peculiar problem is that she pays her cost upfront, but only gets paid at settlement if settlement ever happens. That timing mismatch is what shapes every listing structure that follows. Exclusive right to sell pays the broker no matter who finds the buyer, even the seller herself. Exclusive agency pays other brokers only, letting the owner sell commission-free. Open listings let several brokers compete, paying only whoever procures the buyer. And net listings, where the agent keeps everything above a set price, are banned in Virginia. That's why exclusive rights to sell dominates residential practice. A broker protected from a private deal will invest real money in marketing, because spending now predictably connects to payment later. Expose her to that risk instead, and she rationally holds back. Two mechanics apply across listings. Every agreement needs a definite termination date, and most carry a protection period. So a commission stays owed if a buyer, the broker introduced during the term, later buys after expiration. Whenever a stem shows up, watch for the deciding phrase. No matter who finds the buyer means exclusive right to sell. Unless the owner sells it herself means exclusive agency, and only the procuring broker gets paid means open. Question 11. A house being sold in Virginia Beach sits inside a locally designated tourism activity zone, and the seller asks whether the disclosure chapter obligates her to say so. Getting this wrong would be costly for at least one party. Which of the following describes that particular disclosure? Your options are A. Required in every transaction within the zone, B. Required only if the buyer asks, C. Prohibited unless the locality consents, D. Permissive so the owner may disclose. Before I reveal it, which one do you think is right? The correct answer is D. Permissive so the owner may disclose. D is correct because the tourism activity zone provision is a permissive disclosure, meaning the owner may make it rather than must. Its section title says so, which sets it apart from the required disclosures around it. A is wrong because most disclosures in the chapter are mandatory, which is exactly why this one gets tested. The General Assembly wrote it as an option available to an owner who wants to raise the subject. B is wrong because conditioning the duty on a buyer's question describes no provision in the chapter. Required disclosures run automatically, and this one runs only if the owner chooses to make it. C is wrong because nothing forbids the disclosure or routes it through local government. The locality designates the zone, and the owner decides whether to mention it to a purchaser, which is why the distinction is worth memorizing. Virginia's disclosure chapter uses two very different verbs, and the whole exam question turns on telling them apart. One creates a duty, the other creates an option. Virginia's core disclosure form isn't a checklist about the roof or the furnace. It's a statement where the owner disclaims representations entirely and buyer diligence fills the gap. Against that baseline, the legislature carved out narrow exceptions. 3 narrow facts are mandatory because they're hidden and serious: unremediated methamphetamine manufacture, pending building or zoning violations, and a last pendants. A tourism activity zone is different. It's permissive, not required. A tourism activity zone is a public land use designation, adopted through a public process and sitting in public records. Nothing an owner is hiding, and nothing a buyer's own research couldn't find. Because the zone's value depends on the buyer, a selling point to some, a drawback to others. The law leaves disclosure optional rather than forcing an owner to characterize her own neighborhood. Spot the operative verb and the whole family of questions falls into place. Question 12. An appraiser valuing a house in Charlottesville has completed all 3 approaches and arrived at 3 different indicated values. She now weighs them according to the reliability of the data behind each. Which of the following describes that step? Your options are A. Averaging the 3 indicated values, B. Applying the principle of contribution, C. Reconciliation of the value indications, D. Adjusting the comparable sales again. What's your answer? Commit to one before I continue. The correct answer is C. Reconciliation of the value indications. C is correct because reconciliation is the appraiser's analysis of the value indications, weighing each according to the quality of its data and its relevance to the assignment before stating a final opinion of value. A is wrong because a simple average would give equal weight to an approach the appraiser barely trusts. Reconciliation exists precisely because the 3 indications rarely deserve equal treatment, and it would leave the real issue untouched. B is wrong because contribution measures how much one component adds to overall value, which explains why a costly kitchen may return less than it cost. It operates inside an approach rather than across 3. D is wrong because adjustments happen within the sales comparison approach and are finished before an indication emerges. Reconciliation looks across the finished indications rather than reopening one of them, and the practical result would be quite different. 3 value indications, 1 final opinion. The step that turns those 3 numbers into a single supportable figure is called reconciliation, and it is nothing like taking an average. Reconciliation means weighing each value indication by the quality and quantity of data behind it and its relevance to the assignment, then landing on a single stated opinion of value with a documented rationale. The weight given to each approach depends on the property. Houses get compared to houses, so sales comparison dominates there, while apartments and leased commercial property are priced by investors on income, so that approach carries the most weight. Reconciliation actually happens twice. First, within the sales comparison approach, individual comparables are reconciled into one indication. Then that indication is reconciled again against the cost and income approaches to reach the final opinion. Averaging treats weak data and strong data as equals, which is exactly what reconciliation is designed to avoid. Whenever a question resembles dividing by 3, reject it. Sound appraisal practice weighs, it never averages. Question 13. Brokers from 3 competing firms meet for coffee in Alexandria and agree that none of them will quote a listing fee below a stated figure this year. The correct label is what determines the rights of the parties. Which of the following describes that agreement? Your options are A. Lawful trade practice among independent firms. B. Price fixing, a violation of antitrust law. C. Permissible if disclosed to every client. D. A group boycott of discount brokerages. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is B. Price fixing, a violation of antitrust law. B is correct because competitors agreeing on the fees they will charge is price fixing. Commissions must be set independently by each firm and negotiated with each client, and the agreement is unlawful whether or not it succeeds. A is wrong because independence is exactly what the agreement destroys. Firms may set whatever fees they like on their own, and the moment they coordinate, the conduct becomes an antitrust problem. C is wrong because telling clients about an unlawful agreement does not cure it, and a client who learned of it would have every reason to complain. Disclosure is not a defense to price fixing. D is wrong because a group boycott is a separate antitrust violation in which competitors agree to refuse to deal with someone. These brokers agreed on price rather than on whom to shun. 3 brokers agree over coffee to never quote below a certain fee. No contract, no client harmed, maybe no follow-through at all. The violation is already complete the moment they agree. Federal law treats price fixing as a per se violation, meaning courts never ask whether the price was reasonable or whether harm occurred. The usual reasonableness defense simply doesn't exist here, and the agreement doesn't even need to be written down. The real trouble often isn't a secret handshake, it's vocabulary. Saying a fee is the standard commission or what everyone charges implies the rate is a market fact rather than one firm's independent decision, and that sentence alone can hand a plaintiff's lawyer their case. Price fixing has 3 siblings. A group boycott is refusing to deal with a firm, like shunning discount brokerages. Market allocation divides territory or price ranges so firms stop competing. A tie-in forces the purchase of one thing to get another. Disclosure cures conflicts of interest, but antitrust violations injure competition itself, and no client can consent on behalf of the entire market. Telling a seller he's overcharged doesn't make it legal. It just hands him the facts for a lawsuit backed by criminal exposure, treble damages, and license discipline. Question 14. A listing broker in Suffolk agrees to pay part of her fee to the broker who brings the buyer. The seller assumes that paying the other firm makes it answerable to him. Which of the following describes Virginia's rule? Your options are: A. Payment of compensation creates no brokerage relationship. B. The paying party becomes an additional client. C. The cooperating broker becomes a subagent. D. Payment creates a relationship absent written objection. Which would you go with? Lock it in before the reveal. The correct answer is A. Payment of compensation creates no brokerage relationship. A is correct because the payment or promise of compensation to a real estate broker does not create a brokerage relationship between any broker, seller, landlord, buyer, or tenant. Representation follows the brokerage agreement instead. B is wrong because client status arises from a signed brokerage agreement engaging the licensee. A seller cannot acquire a second firm's loyalty simply by agreeing that his own broker will share the fee. C is wrong because subagency describes an arrangement where one broker works under another's authority for the same client. Virginia's statute severs the link between paying a fee and acquiring that standing. D is wrong because silence creates nothing. The rule operates by its own force, and no party has to object in writing to prevent a relationship. The statute says never formed, and it would leave the real issue untouched. There's an old folk rule in real estate: whoever pays is the client. Virginia rejected that rule by statute, and understanding why reveals how brokerage relationships really work. Before the statute, offering compensation through a shared listing database was widely understood to also offer subagency, meaning the buyer's helpful agent could secretly owe fiduciary duties to the seller, Virginia's law severed that link entirely. Picture two separate tracks. Money flows one way through commission the splits, while representation flows entirely through a signed brokerage agreement. The statute keeps these tracks from ever touching. In Virginia, representation comes from exactly one source: a written brokerage agreement identifying the client, the scope, the term, and the compensation. Signing that document is what creates client status, not paying, cooperating, or sharing data. So whenever a question mentions a fee split or a cooperating broker, ignore who paid whom. Look for the brokerage agreement, because in Virginia, that document alone settles who represents whom. Question 15. A seller in Winchester conveys by deed in which she promises to defend the buyer against title claims arising at any point in the property's history, not merely during her own ownership. Which of the following deed does that describe? Your options are a quitclaim deed, B, a special warranty deed, C, a bargain and sale deed, D, a general warranty deed. Don't overthink it. Which one feels right? The correct answer is D, a general warranty deed. D is correct because a general warranty deed carries the full covenants of title and warrants against defects arising at any time, including before the grantor owned the property. It gives a buyer the broadest protection available. A is wrong because a quitclaim deed conveys whatever interest the grantor happens to have and warrants nothing at all. It is used to clear clouds on title rather than to transfer a home in an arm's length sale. B is wrong because a special warranty deed limits the grantor's promise to claims arising during her own period of ownership. Anything predating her purchase is the buyer's problem, and the scenario gives no footing for it. C is wrong because a bargain and sale deed implies that the grantor holds title but carries no express warranties unless covenants are added. It sits between a quitclaim and a warranty deed. A deed transfers ownership, but it doesn't automatically promise that ownership is any good. Those promises are separate, called covenants of title, and they're the entire difference among the deed types you'll see tested. The present covenants are size and the right to convey and against encumbrances. The future covenants are quiet enjoyment, warranty, and further assurances, and they protect the grantee against problems that surface after closing. A general warranty deed defends against defects from any point in history. A special warranty deed limits that promise to the grantor's own ownership period. A bargain and sale deed implies title with no express warranty. A quitclaim promises nothing at all. Picture the property's whole history as one long timeline. A general warranty deed covers all of it, even decades before the seller owned it, while a special warranty deed only covers the stretch she actually held title. A warranty is only a promise from a person, who may be unreachable years later, while title insurance is backed by a solvent company that pays as claims arise. Remember, the reach of the promise defines the deed, but insurance is what actually shows up. Question 16. A buyer's agent in Blacksburg learns that her client is willing to pay considerably more than the offer he plans to submit on a property. Which of the following governs her handling of that information under general agency principles? Your options are A. Duty of confidentiality owed to the client, B. The duty of honesty owed to customers, C. The duty to account for funds received, D. The duty of reasonable care and inspections. Got a guess? Lock it in. The correct answer is A. Duty of confidentiality owed to the client. Is correct because confidentiality bars an agent from revealing information that would weaken her client's bargaining position. A buyer's ceiling price is the clearest example and stays protected even after the relationship ends. B is wrong because honesty runs to the other side of the transaction and forbids affirmative misstatements. It does not require an agent to volunteer what her own client can afford to pay. C is wrong because accounting concerns money and property the agent receives on the client's behalf, such as an earnest money deposit. It has nothing to do with what the client says about his budget. D is wrong because reasonable care governs the quality of the agent's work in advising and handling the transaction. It does not tell her what she may repeat to the seller side. Confidentiality in agency isn't about secrets in general. It's a narrower rule. An agent may never disclose information that would weaken her client's bargaining position. On the buyer side, that means the real ceiling price and any motivation, like a relocation deadline or a lease expiring. On the seller side, it mirrors that. The lowest number they'd accept, a divorce, a job transfer, or prior deals that fell through. When a brokerage agreement ends, nearly every statutory duty ends with it. To survive, accounting for money and property and confidentiality, which last indefinitely absent client consent, or a legal requirement to disclose. The exceptions are narrow. A client may authorize disclosure, a court can compel it, and confidentiality never covers concealing a material defect or supporting a misrepresentation. Honesty and confidentiality aren't in tension. Honesty bans lying, confidentiality bans volunteering. An agent asked if her buyer could pay more need not lie, but she also doesn't have to answer, and that's exactly why dual representation is so structurally difficult. Question 17. A purchase contract on a Manassas townhouse states that time is of the essence and sets settlement for a specific Friday. The buyer's lender is not ready until the following Tuesday. Which of the following describes the effect of that clause? Your options are: A. Deadlines become suggestions once financing is delayed. B. Seller must grant a commercially reasonable extension. C. Deadlines must be met exactly. D. Clause applies only to the seller's obligations. Which one is it? Pause the video if you need more time. The correct answer is C. Deadlines must be met exactly. C is correct because A time is of the essence clause makes each stated deadline a material term. Missing settlement by even a few days places the delayed party in default unless the other side agrees in writing to extend. A is wrong because treating deadlines as flexible would strip the clause of any purpose. Parties insert it precisely because one of them cannot tolerate slippage in the schedule, which is a common but costly substitution. B is wrong because nothing obligates a seller to extend, though many do because a new buyer means new marketing time. An extension is a favor the parties negotiate rather than a right the buyer holds. D is wrong because the clause binds both sides equally. A seller who cannot deliver possession or clear title on the stated date is in default on the same terms as a late buyer. Contract deadlines are more forgiving than most people think until one clause changes everything. Absent special language, courts generally treat a stated date as flexible. A short delay counts as substantial performance rather than breach, so a buyer who shows up a few days late with the money is normally still entitled to close. A time is of the essence clause flips this default. It turns every stated deadline into a material term, so missing the settlement date, an inspection deadline, or a financing date is an immediate material breach rather than a minor lapse. Real transactions sit in chains. A seller may need these proceeds to close on her own new house that afternoon. A rate lock may be about to expire, or an investor may face a tax-deferred exchange deadline where any slippage is costly. The clause applies equally to both sides. A seller who isn't ready is just as much in default as a late buyer, and while sellers often grant extensions informally, that is a negotiated favor requiring a signed addendum, not an automatic right. Granting one too casually can even waive the clause going forward. Question 18. The Virginia Real Estate Board asks the principal broker in Newport News to produce bank records and transaction documents connected with a complaint under investigation. The correct rule matters more than the customary practice does. Which of the following states the time allowed for that production? Your options are A. 5 business days from the request, B. 21 days from the request, C. 30 calendar days from the request, D. 10 days, extendable for extenuating circumstances. Take a second. Which answer would you pick? The correct answer is D. 10 days, extendable for extenuating circumstances. D is correct because a licensee must produce signature cards, bank records, and transaction documents within 10 days of a board request, and the board may extend that period on a showing of extenuating circumstances. A is wrong because 5 business days is the escrow deposit window for earnest money and lease funds. It measures how quickly money reaches an account rather than how quickly records reach the board. B is wrong because 21 days is the period for answering any other inquiry from the board or its agents. Document production runs on the shorter clock because the records already exist. C is wrong because 30 calendar days is the reporting period for a name or address change, a conviction, or discipline in another jurisdiction. None of those involves producing a transaction file. Virginia's licensing deadlines feel like a blur of numbers, but they aren't arbitrary. Each clock length matches the difficulty of the task and the urgency of the risk involved. The record production rule sits at the center of this cluster. Virginia already requires brokers to keep transaction and escrow records for 3 years, so a request for those records only demands retrieval, not creation, which is why 10 days is generous but firm. The whole cluster follows one logic. The clock tightens as the task gets simpler and the risk gets more immediate. Escrow deposits get 5 business days because moving money is mechanical and delay risks conversion. Producing records gets 10 days. Responding to a board inquiry gets 21 days since it must be composed and checked. Reporting a name change, conviction, or discipline gets 30 calendar days, since these are routine notifications. One detail decides many exam items whether a deadline counts business days or calendar days. The escrow window is business days, the reporting window is expressly calendar days, and the record production window defaults to calendar days since no business day language is used. When a STEM describes handing over bank records during an investigation, think 10 days. A written inquiry means 21. A conviction or address change means 30 calendar days. Getting earnest money deposited means 5 business days. Match the clock to the act and the numbers stop being a memory test. Question 19. A landlocked parcel in Albemarle County has a recorded right to cross the neighboring farm to reach the public road, and the right passes automatically to whoever owns the landlocked parcel. Which of the following describes that interest? Your options are A. An easement in gross, B. An easement appurtenant, C. A license to cross, D. An encroachment on the farm. Before I reveal it, which one do you think is right? The correct answer is B. An easement appurtenant. B is correct because an easement appurtenant benefits one parcel and burdens another, running with the land so that it passes to each new owner of the dominant tenement without any new grant. A is wrong because an easement in gross benefits a person or a company rather than a parcel, which is why utility easements take that form. Nothing about it transfers automatically with a neighboring tract. C is wrong because a license is revocable personal permission to enter land and creates no interest in the property. The owner could withdraw it tomorrow, which is no help to a landlocked parcel. D is wrong because an encroachment is an unauthorized intrusion of a structure onto a neighbor's land. The right described here was granted and recorded rather than taken without permission, which is a common but costly substitution. A landlocked parcel is legally, not physically, stuck. The owner can see the road, but crossing a neighbor's land without a right is trespass. So the law needs something durable enough to survive a sale and satisfy a lender. An easement is a non-possessory right to use another's land for a stated purpose, and a pertinent means it attaches to land, not a person. The dominant tenement is the landlocked parcel that benefits, and the servient tenement is the neighboring farm that carries the burden. Running with the land is the defining feature, the benefit and burden attached to the parcels themselves, so every future owner automatically gains or inherits them. No new paperwork required, as long as the easement was recorded. Easements arise four ways: express grant in a deed, necessity when severance leaves a parcel landlocked, implication from an apparent prior use, and prescription from open, continuous, hostile use over the statutory period. They also end merger when one owner acquires both parcels, released by the dominant owner, abandonment shown by clear intent rather than mere non-use, and expiration when a term runs out or a necessity disappears. Question 20. An owner in Danville is selling a house that was previously used to manufacture methamphetamine and has never been remediated according to state regulation. It is worth confirming rather than assuming on facts like these. Which of the following describes her disclosure obligation? Your options are: A. No representations under the general statement. B. Disclosure is required only for rentals. C. A required disclosure applies to the sale. D. The locality gives notice at recordation. What's your answer? Commit to one before I continue. The correct answer is C. A required disclosure applies to the sale. C is correct because the chapter contains a required disclosure where property was previously used to manufacture methamphetamine and has not been cleaned according to regulation. A parallel provision applies to residential leases. A is wrong because Virginia's general statement disclaims representations on a long list of subjects and directs the buyer to investigate. Methamphetamine contamination sits outside that list in its own required disclosure. B is wrong because leases do carry their own version of this disclosure, which is why the option feels familiar. The sale side has its own required disclosure in the property disclosure chapter. D is wrong because clerks record instruments and index them and give no notices about a property's history. Nothing in the recording process would alert a purchaser to prior contamination. And the statute takes a different route. Why does Virginia law single out meth lab history for mandatory disclosure? The answer isn't about how dangerous it is. It's about whether an ordinary buyer could ever find out on their own. A home inspector checks systems and structures, not chemical residue in the drywall or ductwork. Fresh paint and new flooring can completely mask a former meth lab, so ordinary diligence turns up nothing. The residue settles into wall surfaces, HVAC ducts, carpet fibers, countertops, and porous materials throughout the home, invisible beneath any surface renovation. Meth residue, a pending zoning violation, and a lis pendens have almost nothing in common as subject matter. What unites them is that no inspector, survey, or land record search would ever reveal them, and that shared invisibility, not severity, is what triggers a mandatory disclosure. Remember the test. If a fact is invisible to inspections, title searches, and land records, the law steps in because the buyer never could. That's the thread connecting every mandatory disclosure in the chapter. Question 21. A borrower misses several payments, and the lender declares the entire remaining balance immediately due rather than suing for the missed installment alone. A licensee who guesses here creates a problem for the client. Which of the following clause permits that step? Your options are: A. The acceleration clause, B. The defeasance clause, C. The subordination clause, D. The prepayment clause. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A, the acceleration clause. A is correct because an acceleration clause lets the lender call the whole balance due on default. Without it, a lender would have to sue for each missed payment as it came due, which is why every loan contains one. B is wrong because a defeasance clause requires the lender to release the security once the debt is paid in full. It governs the end of a healthy loan rather than the lender's response to a default. C is wrong because a subordination clause allows an existing lien to move behind a later one in priority. It matters in construction and refinance settings and says nothing about missed payments. D is wrong because a prepayment clause addresses whether a borrower may retire the loan early and at what cost. The trigger there is the borrower's choice rather than the borrower's failure to pay. Without an acceleration clause, a 30-year note is really a series of separate monthly debts, and a lender could only sue for each missed installment one at a time, forever. The acceleration clause solves this in one sentence. On default, the lender may declare the entire unpaid balance and accrued interest immediately due. That single collapsed debt is exactly what a foreclosure sale exists to satisfy. Default covers far more than skipped payments, failing to pay taxes, letting insurance lapse, permitting waste, or allowing a superior lien or unapproved transfer can all trigger the same remedy, even for a borrower current on payments. Acceleration and alienation are often confused, but they're nested, not parallel. Acceleration is the umbrella remedy for any default. The alienation or due on sale clause is just one spoke under it, triggered specifically by transfer of ownership. Lenders can even decelerate, rescinding the demand if a repayment plan works out. And remember, defeasance ends a healthy loan, subordination reorders liens, and prepayment reflects the borrower's own choice. None of them respond to default the way acceleration does. Question 22. A buyer under contract on a Hampton house transfers her rights to a friend who takes over the purchase. The seller wants the original buyer released from all liability. This is the sort of detail that decides who bears a loss. Which of the following accomplishes that release? Your options are A. An assignment signed by both buyers. B. Recording the assignment with the clerk. C. A notice of substitution to the seller. D. Novation agreed to by all three parties. Which would you go with? Lock it in before the reveal. The correct answer is D. Novation agreed to by all three parties. D is correct because an assignment transfers rights while leaving the original party secondarily liable. Only a novation, in which all parties agree to substitute the new obliger for the old one, releases the original buyer. A is wrong because an assignment between the two buyers moves the benefit of the contract without touching the seller's rights. The seller can still look to the original buyer if the friend fails to close. B is wrong because recording gives notice to the world of an interest in land and changes nothing about who owes what. A recorded assignment is still an assignment, so the option is off the mark. C is wrong because a notice tells the seller what happened and asks nothing of him. Releasing a party from an obligation requires his agreement, not merely his awareness, and the surrounding provisions confirm as much. An assignment moves rights from one party to another, but it does not erase the person who made the original promise. That single distinction explains most of the confusion in this area of contract law. In an assignment, the assignee steps into the assigner's position and can enforce the contract, even taking on delegated duties. But absent a release, the original party remains secondarily liable, so if the assignee fails to perform, the other side can still come after the original party. Novation is what actually produces a release. It substitutes a new party for an original one, discharging the original entirely, but only when three ingredients line up: a valid prior obligation, the agreement of every party involved, and a clear intent to extinguish the old obligation rather than just add to it. The same structure governs loan assumptions. When a buyer assumes an existing deed of trust, the original borrower stays liable on the note unless the lender executes a release, leaving her exposed to a deficiency on property she no longer owns. Consent is the heart of it. A seller bargained for a specific counterparty, and no one can strip him of that claim without his agreement, so watch the stem. Words like discharged or substituted signal novation, while transferred her rights or stepped into the contract signal assignment, with the original party still on the hook. Question 23. A Virginia seller asks her listing licensee what the statute actually requires when a written offer arrives on a property that is already under contract with another buyer. The consequence follows entirely from which rule applies. Which of the following states that duty? Your options are A. Hold it until the contract fails. B. Refer it to the principal broker. C. Present it to the seller promptly. D. Return it to the offering licensee unopened. Don't overthink it. Which one feels right? The correct answer is C. Present it to the seller promptly. C is correct because the statutory duty to promote the seller's interest includes presenting all written offers and counter-offers in a timely manner, expressly including situations where the property is already subject to a contract. A is wrong because holding the offer would keep the seller from learning about a backup he might want. The statute anticipated the situation and closed the door on it in so many words. B is wrong because the principal broker supervises the transaction and does not stand between a licensee and her client. The offer belongs in front of the seller who has to decide what to do with it. D is wrong because refusing delivery would also violate the board's rule requiring prompt tender of every written offer, counter-offer, and rejection to the client or unrepresented party, which is a plausible guess and nothing more. A house is already under contract. A second higher offer arrives. Can the listing agent quietly file it away to protect the deal? The answer is no, and the reasoning behind that answer reveals a core principle of agency law. A second offer is not a nuisance to be managed. It is information with real value, and every possible use of it belongs to the seller. He might accept it as a backup, hold it as leverage if the first buyer asks for concessions later, judge it weaker and decline it, or simply want to know. The principle underneath is simple. An agent cannot substitute her own judgment for her client on a choice the client is entitled to make. Deciding whether to tell the seller about an offer is not a separate, lesser decision. It is the same decision, just made in secret. This isn't a matter of inference. The Virginia statute names this exact scenario, requiring presentation even when a contract already exists, and a board regulation reinforces it by requiring prompt tender of every offer, counter-offer, and rejection directly to the client. Routing the offer to the principal broker instead, or holding it until the first deal falls through. Both fail for the same reason. They let the agent decide what only the client may decide. The duty holds as long as the relationship exists, and it exists precisely to override the instinct to protect a deal by hiding the truth. Question 24. A seller is marketing a house in Petersburg that was built in 1962. The buyer's agent asks what federal law requires before the contract becomes binding. The rule and the customary practice are not the same thing. Which of the following describes that requirement? Your options are A. Certified inspection paid for by the seller. B. Disclosure, pamphlet, and inspection opportunity. C. Abatement of any painted surfaces disturbed. D. A notice recorded in the land records. Got a guess? Lock it in. The correct answer is B. Disclosure, pamphlet, and inspection opportunity. B is correct because for target housing built before 1978, the seller must disclose known lead-based paint and hazards, provide the federal pamphlet, and give the buyer 10 days to conduct an inspection. A is wrong because the rule offers the buyer an opportunity rather than compelling a test, and it does not assign the cost to the seller. Buyers frequently waive the period in writing. C is wrong because abatement is a remediation decision an owner may or may not make. Federal disclosure law addresses information rather than requiring anyone to remove paint before a sale, which is where candidates most often slip. D is wrong because nothing about the requirement touches the land records. The disclosure and the acknowledgement travel with the contract file rather than being recorded against the property, and it answers a problem nobody raised here. Lead-based paint was banned in US homes in 1978, and that date created a federal disclosure rule for older housing. It's crucial to understand this is an information statute, not a safety statute. Lead is a neurotoxin, and the danger isn't paint on a wall, but the dust it sheds as it deteriorates or as windows and doors rub against their frames. Small children ingest that dust through ordinary hand-to-mouth behavior, and the resulting nerve damage is permanent, often occurring before any visible symptoms appear. For target housing built before 1978, 3 obligations attach before the contract binds, and everyone concerns information, not remediation. The seller discloses known hazards and records, provides the federally approved pamphlet, and gives the buyer a 10-day window to inspect at her own expense. 1978 is the dividing line. Housing built before that year is target housing and falls under the rule, while newer housing does not, aside from narrow exclusions like 0-bedroom units. A house built in 1962, for example, sits squarely inside the category. The rule never requires testing, seller-paid inspection, abatement, or recording anything in land records. It only requires disclosure. A buyer who wants certainty gets it by using her inspection period, not by demanding remediation the statute never promised. Question 25. A licensee in Chesapeake plans a telephone campaign to homeowners whose listings expired without selling. Her broker reminds her of a federal compliance step before she begins dialing. The answer decides how the file is handled from here. Which of the following is that step? Your options are A. Screening the numbers against the National Registry. B. Filing a call list with the board. C. Written consent from the listing service. D. Recording every call for later inspection. Which one is it? Pause the video if you need more time. The correct answer is A. Screening the numbers against the National Registry. A is correct because federal rules require a caller to scrub prospecting list against the National Do Not Call Registry and to honor company-specific requests. Established business relationships create only limited exceptions. B is wrong because the board licenses and disciplines and maintains no telemarketing lists. Filing anything with it would neither satisfy federal law nor protect the licensee from a complaint, which is more appealing than accurate. C is wrong because a listing service governs data sharing and cooperation among participants. Its consent has no bearing on whether a consumer may lawfully be called at home, and nothing about the timing works out. D is wrong because some states regulate call recording and require consent from the parties. Recording is not the federal compliance step, and doing it without consent can create its own liability. Expired listings are prospecting gold, but they're also the most legally loaded list a licensee can touch, because federal telemarketing law doesn't care that the caller holds a real estate license. The framework rests on 2 layers: the National Do Not Call Registry, which every licensee must scrub against before calling, and the firm's own internal Do Not Call list. A consumer's request to that specific firm outranks everything, even exceptions that would otherwise permit the call. Picture 2 separate filters standing between a licensee and a phone call. The registry catches anyone nationally opted out, while the internal list catches anyone who personally told that firm to stop. Both must clear before dialing. Only two real exceptions exist: express written consent and an established business relationship, which lasts a short window from the last transaction. Neither is created by an expired listing with another firm, and neither is created by a number simply appearing in a shared database. When a question mentions cold calling expired listings, the first tested step is the registry scrub, and the second, more commonly violated step, is respecting that firm's own internal do not call request. Question 26. A Virginia principal broker is setting up the bookkeeping for money she receives on behalf of others and wants to capture exactly what the record-keeping regulation requires for each deposit. Which of the following lists those data points? Your options are A. Payer, amount, and intended purpose. B. Account number, balance, and reconciliation date. C. Client name, property address, and closing date. D. From whom dates and place of deposit. Take a second. Which answer would you pick? The correct answer is D. From whom dates and place of deposit. D is correct because the regulation requires records showing from whom money was received, the date of receipt, the place of deposit, and the date of deposit, along with a bookkeeping system demonstrating full compliance. A is wrong because amount and purpose obviously appears somewhere in a competent set of books. The regulation names 4 specific points, and 2 of them concern where and when the money landed. B is wrong because account numbers and balances appear on statements the broker keeps and produces on request. They describe the account rather than the individual receipt the rule tracks, so it cannot govern this particular outcome. C is wrong because client and property identifiers organize a transaction file and are needed for the 3-year retention requirement. They are not the 4 items this particular rule enumerates, and no authority reads it that way. Escrow record-keeping rules exist for one reason: to let an auditor trace exactly where a client's dollar came from when it arrived and where it ended up. The regulation names 4 data points for every deposit: from whom the money was received, the date of receipt, the place of deposit, and the date of deposit. 2 of the 4 points are dates because receipt and deposit are separate events, and the law gives brokers only 5 business banking days between them. Recording both dates independently is the only way to reveal a dangerous delay, which is the classic warning sign of conversion. From whom the money was received proves attribution when parties dispute a deposit. Place of deposit proves the funds never touched the firm's operating account, guarding against commingling. And the 2 dates together prove there was no dangerous delay. Amount, client names, and account balances are all real records a broker keeps, but they describe the transaction, not the money. The regulation's 4 points exist only to reconstruct the path of a single dollar. Question 27. An appraiser is asked to distinguish the price a particular buyer actually paid from the value her assignment is meant to estimate. The answer shapes the obligations each party carries forward. Which of the following best describes market value? Your options are A. Amount the last buyer agreed to pay. B. The cost to replace the improvements today. C. The most probable price under competitive conditions. D. The assessed value shown in local records. Before I reveal it, which one do you think is right? The correct answer is C. The most probable price under competitive conditions. C is correct because market value is the most probable price a property should bring in a competitive and open market, with buyer and seller each acting prudently, knowledgeably, and without undue pressure. A is wrong because price is what one buyer paid on one day and may reflect an unusual motivation, a relationship between the parties, or simple error. Value describes what a typical transaction should produce. B is wrong because replacement cost measures what it would take to build again and feeds the cost approach. A building can cost far more to replace than the market will pay for it. D is wrong because assessed value drives the local tax bill and is set on a reassessment cycle. Virginia assesses at full fair market value, and even so the figure lags the market between reassessments. Everyday speech treats price, cost and value as the same thing, but appraisal depends on keeping them apart. Price is what someone paid. Cost is what it took to build or acquire. Value is an opinion about what a property should bring, and there is no guarantee any two of these produce the same number. Market value is the most probable price a property should bring in a competitive, open market with informed, prudent parties acting freely and without pressure. Most probable means the central expectation of likely outcomes, not the highest price ever obtained. Open market means the property had reasonable exposure time to find its buyer pool, and prudent, knowledgeable assuated annexes et salon. Unpressured parties rules out duress like foreclosure, divorce deadlines, or sales between relatives. Price is a fact about one transaction, and it frequently fails the assumptions behind market value, since it might reflect a rushed seller, an uninformed buyer, or a family favor. Cost measures what it would take to build a replacement today, and it can run far above what any buyer would actually pay. Assessed value, set by the locality for taxation, lags the market and routinely disagrees with the current appraisal. Investment value is worth to one particular investor, given her financing and tax position, and it is deliberately not market value. Value in use is worth to a particular owner for a particular purpose, which can sit far above or below what the open market would pay. Market value alone describes worth to the market as a whole, not to any one person. When a question emphasizes most probable price, open competitive market, or the absence of pressure, it is pointing to market value. When it emphasizes what one buyer actually paid, that is price. When it emphasizes construction expenditure, that is cost. And when it references the tax roll, that is assessed value. Question 28. 3 siblings inherit a house in Staunton and hold it in equal shares, each free to sell or devise her share to whomever she chooses. The paperwork will read differently depending on the answer. Which of the following form of ownership does that describe? Your options are A. Tenancy in common, B. Joint tenancy with survivorship, C. Tenancy by the entirety, D. Ownership in severalty. What's your answer? Commit to one before I continue. The correct answer is A. Tenancy in common. I is correct because tenants in common hold undivided interests that may be unequal, and each owner may convey or devise her share freely. There is no right of survivorship among them. B is wrong because survivorship would send a deceased sibling's share to the other two rather than to her heirs, which contradicts the freedom to devise described here. Virginia also requires express survivorship language. C is wrong because tenancy by the entirety is available only between spouses and cannot exist among siblings. It also carries survivorship, and neither spouse may convey a loan, which the question deliberately tests against. D is wrong because severalty means ownership by one person alone. 3 co-owners cannot hold in severalty no matter how their shares are divided, and the governing text points the other way. 3 siblings inherit a house, each with a 1/3 share they can sell or leave to anyone they choose. That's a tenancy in common, the default form of co-ownership in Virginia, and understanding why it defaults this way unlocks the whole topic. Each co-tenant owns an undivided fractional interest in the entire property, not a specific room or slice. Shares need not be equal. Interest can be sold or left by will, and only one unity is required: possession. The defining feature is that there's no survivorship. A deceased tenant's share passes to her heirs, not the other owners. Joint tenancy carries survivorship but demands the 4 unities: same interest, instrument, time, and possession, plus Virginia requires express survivorship language. Tenancy by the entirety is reserved for spouses, adds marriage as a fifth unity, and shields property from a creditor of just one spouse. Severalty, despite sounding plural, means sole ownership by one person alone. Picture the whole house, not divided into thirds by walls, but with each sibling's fractional interest overlapping every square foot. That's what undivided means. Each owner has the right to possess and use the entire property, not just a carved-out portion. Whenever co-ownership becomes unworkable, any co-tenant can bring an action for partition, dividing the property, or far more often, selling it and splitting the proceeds by share. No one can be trapped as a co-owner indefinitely. Question 29. A buyer brokerage agreement in Arlington reaches its termination date without a purchase, and the licensee still holds an earnest money deposit from an offer that failed. The point is worth settling before anything else moves forward. Which of the following duty survives the termination? Your options are A. Continuing to search for suitable properties. B. Accounting for money and property received. C. Presenting late offers to the client. D. Advising on the market for another year. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is B. Accounting for money and property received. B is correct because two duties survive termination: accounting for all money and property relating to the relationship, and maintaining confidentiality. Everything else in the statutory duty list ends with the engagement. A is wrong because searching for property is the core of active representation and stops when the agreement ends. Continuing would suggest a relationship the parties chose not to renew, which practitioners learn to separate early. C is wrong because presenting offers is a duty owed to a current client. Once the engagement has ended, there is no client to present anything to and no authority to negotiate. D is wrong because ongoing advice would extend the relationship indefinitely without a written agreement, which Virginia requires before brokerage services may be provided at all, so the label does not fit these facts. While a brokerage relationship exists, a licensee owes a full slate of duties. But when that relationship ends, nearly all of them switch off, except two, and knowing which two matters more than knowing the whole list. Termination happens in several recognized ways: performance at closing, expiration of the stated term, mutual agreement in writing, default by either party, statutory conditions tied to dual representation, and operation of law such as death or bankruptcy. Everything tied to ongoing effort: searching for properties, advising on the market, presenting offers, disclosing facts, ends the moment the relationship ends. Only two duties survive: accounting for money and property and maintaining confidentiality. The logic is simple. Every duty that ends concerns effort, which is exactly what the engagement purchased. But money and information were entrusted, not purchased as effort, so a date passing can't return them, which is why accounting and confidentiality outlive the relationship itself. Consider earnest money still sitting in escrow after a buyer agreement expires. That money doesn't become the broker's, doesn't leave with the relationship, and can't be released on request alone. It can only be dispersed by agreement of the parties, a court order, or interpleader. When you see an expired agreement, a completed closing, or a terminated relationship on an exam, ask only whether money or information is still in the licensee's hands. That's the only thing left to owe. Question 30. An owner of a small apartment building in Lynchburg engages a property manager and asks what document establishes the manager's authority and compensation. Nothing about the situation is unusual, but the label matters. Which of the following instrument does that? Your options are A. The lease with each individual tenant. B. The declaration recorded against the property. C. A brokerage agreement with the buyer. D, the property management agreement. Which would you go with? Lock it in before the reveal. The correct answer is D, the property management agreement. D is correct because the property management agreement is the contract between owner and manager. It sets the scope of authority, the compensation, the reporting duties, and the term of the engagement. A is wrong because leases create the relationship between the owner and each tenant and say nothing about what the manager may do. A manager signs leases under authority granted somewhere else. B is wrong because a recorded declaration creates a common interest community and binds unit or lot owners. It has no role in a single owner's private arrangement with the manager, so it answers a question that was not asked. C is wrong because a brokerage agreement engages a licensee to help a client buy, sell, or lease. Management is its own engagement with its own statutory duty list in Virginia, and no part of the record supports that reading. Property management is not a branch of a brokerage relationship. It's its own service, with its own contract and its own duties. That contract is the property management agreement, and everything the manager may lawfully do traces back to it. At minimum, the agreement settles 4 subjects: the scope of the manager's authority, her compensation, her reporting and accounting duties, and the term and conditions for termination. Of these, authority carries the most weight, because a manager acts constantly and can't call the owner before every decision. This is where agency classification matters. A listing broker is a special agent, hired for one transaction with narrow authority. A property manager is a general agent, holding continuing authority across an ongoing series of transactions, which means her acts within apparent authority can bind the owner even if she privately exceeded her instructions. Don't confuse the management agreement with 3 lookalikes. A lease governs the owner-tenant relationship, but says nothing about the manager's authority. A declaration binds every owner in a community, not one owner and one manager. A brokerage agreement covers representing a client in a sale. Only the management agreement defines the manager's authority, pay, and duties. Whenever a question describes establishing a manager's authority, compensation, or scope of engagement with an owner, the answer is the property management agreement. Question 31. A subdivision in Chesterfield County restricts homes to 2 stories by recorded covenant, while the zoning ordinance would permit 3. A buyer asks which limit governs his building plans. Practitioners meet this question regularly and answer it wrongly. Which of the following is correct? Your options are: A. The zoning ordinance always preempts private covenants. B. Buyer may choose whichever limit he prefers. C. The more restrictive of the 2 controls. D. The covenant lapses when zoning changes. Don't overthink it. Which one feels right? The correct answer is C, the more restrictive of the 2 controls. C is correct because public land use controls and private restrictions operate independently, and an owner must satisfy both. Where they conflict, the more restrictive limit governs what may actually be built. A is wrong because zoning sets a public ceiling and does not license an owner to breach a private promise recorded against his own land. Neighbors may enforce the covenant regardless of what the ordinance allows. B is wrong because choice would let an owner ignore an obligation that ran with the land when he bought it. The covenant bound him the moment he took title, and the rule at issue reaches further than that. D is wrong because covenants run with the land until they expire by their terms, are released, or are abandoned. A change in the zoning map does not extinguish a private agreement among owners. 2 separate systems of land use control sit on the same parcel at once, and they answer to different masters. Zoning is a public ordinance enforced by the locality through permits and citations. Restrictive covenants are private promises recorded by the developer, enforced by neighbors or the homeowners association. Neither system cares what the other says, so an owner must comply with both at once. Covenants bind successors only when three conditions are met. The original parties intended the restriction to bind future owners, the covenant touches and concerns the land, and recording gives constructive notice to every later buyer, whether or not they actually read it. Covenants end only through narrow routes. They expire by their own stated duration, get released or amended by the required percentage of owners, are abandoned through widespread tolerated violation, or are extinguished by merger when one owner acquires all the burdened and benefited land. A zoning change is not on that list. The locality enforces zoning and has no say over covenants. Neighbours and associations enforce covenants and have no power over permits. Whichever limit is stricter sets the real ceiling, because it's the only one that satisfies both obligations at once. Question 32. A purchase contract on a house in Roanoke County states that if the buyer defaults, the seller's sole remedy is to retain the deposit. The buyer walks away and the seller wants to sue for more. Which of the following applies? Your options are: A. Seller keeps the deposit as liquidated damages. B. The seller may recover actual proven losses. C. The clause is unenforceable against a consumer. D. The seller must elect specific performance instead. Got a guess? Lock it in. The correct answer is A. Seller keeps the deposit as liquidated damages. A is correct because a liquidated damages clause fixes in advance what a defaulting party owes, and where it names the deposit as the sole remedy, limits the seller to that amount rather than to proven losses. B is wrong because actual damages are what a seller recovers when the contract is silent. The parties here bargained for certainty instead, which is the entire point of the clause, and the rule was written to prevent exactly that. C is wrong because liquidated damages provisions appear in standard residential contracts throughout Virginia and are routinely enforced. Courts strike them only where the amount is a penalty rather than a reasonable estimate. D is wrong because specific performance compels a reluctant party to complete the sale and is ordinarily the buyer's remedy against a seller. Nothing requires a seller to pursue it before keeping a deposit. When a buyer defaults on a real estate contract, the seller's remedy is often fixed in advance, not calculated after the fact. That fixed amount is called liquidated damages, and understanding why it works this way explains a whole category of exam questions. A liquidated damages clause substitutes a stipulated sum, usually the earnest money deposit, for the messy job of proving actual loss. Both parties trade the chance of a more precise number for certainty and a quick resolution. Courts look backward to the moment of contract formation, not forward to the actual outcome. The clause is enforced if damages were hard to estimate then, and the amount was a reasonable forecast of probable loss. Otherwise, it's struck down as a penalty. The exact wording matters enormously. A clause that just says, the seller may retain the deposit may leave other remedies open. But language declaring it the sole and exclusive remedy caps recovery there. And most Virginia residential forms use that exclusive language. The clause is often framed as protecting sellers, but its deeper purpose is shielding buyers from open-ended liability in a falling market. Both sides accept a known, bounded outcome, and that symmetry is exactly what was bargained for. Question 33. A buyer financing a purchase in Prince William County learns that the lender requires a title policy, but that the policy covers only the loan balance. Which of the following describes what she needs for her own protection? Your options are A survey endorsement on the lender's policy. B. Recorded affidavit of title from the seller. C. An extended warranty from the settlement agent. D. An owner's title insurance policy. Which one is it? Pause the video if you need more time. The correct answer is D, an owner's title insurance policy. D is correct because a lender's policy protects the lender up to the loan amount and declines as the loan is repaid. Only an owner's policy protects the buyer's own equity against defects in the title she received. A is wrong because an endorsement broadens the coverage of a policy that already exists. Adding one to the lender's policy still leaves the insured party the lender rather than the buyer. B is wrong because an affidavit of title is the seller's sworn statement about liens, parties in possession, and similar matters. It supports the title examination without insuring anyone against loss, and the difference matters in practice. C is wrong because settlement agents record documents and disperse funds and issue no warranties on title. Their errors are covered by their own professional insurance rather than by a product sold to the buyer. At a residential closing, two separate title insurance policies are created from the same title search, but they protect completely different people. The loan policy protects only the lender, ensuring the shrinking loan balance until the mortgage is paid off. The owner's policy protects the buyer, is written for the full purchase price, and lasts as long as she or her heirs own the property. Title insurance is unusual because it looks backward, not forward. It covers defects that already existed before closing but slipped past the search, like a forged deed, an undisclosed heir, a defective probate, a missing signature, a recording error, a late mechanic's lien, or a hidden easement. An endorsement only broadens an existing policy's coverage. It never changes who is insured. So adding one to the lender's policy still leaves the buyer unprotected. An affidavit of title is just the seller's sworn statement and it pays nothing. And the settlement agent's insurance protects the agent, not the buyer. The most valuable feature is the duty to defend. If a claim arises, the insurer funds the legal battle. Without her own owner's policy, none of that protection belongs to the buyer. Question 34. A seller in Portsmouth has an open citation from the locality for an unpermitted rear addition, and the matter is unresolved when she lists the property. Both sides have a real interest in getting this right. Which of the following describes her obligation under the disclosure chapter? Your options are: A. The general statement covers it. B. Disclosure is required only after a hearing. C. A required disclosure covers pending violations. D. The locality notifies the purchaser directly. Take a second. Which answer would you pick? The correct answer is C. A required disclosure covers pending violations. C is correct because the chapter contains a required disclosure covering pending building or zoning violations, standing apart from the general statement in which the owner makes no representations about condition. A is wrong because the general statement disclaims representations and points the buyer toward investigation. A pending violation is a known legal problem rather than a condition the buyer might discover by inspecting. B is wrong because waiting for a hearing would let a seller close while an enforcement action was still developing. The disclosure attaches to the pending status itself, so it leaves the central question open. D is wrong because localities pursue enforcement against the owner of record and issue no notices to prospective purchasers. A buyer would learn nothing until the citation followed her into ownership, and the rule was written to prevent exactly that. Let's look at why Virginia ties this disclosure duty to the word pending and what that word is doing in the statute. A notice of violation starts a clock, an order to correct accruing civil penalties, and in extreme cases an injunction or an order to remove the structure. That obligation attaches to the land itself, so it follows the property into a new owner's hands. The duty attaches to the mere existence of an unresolved matter, not to a final determination. No hearing, no adjudication, no admission is required because enforcement cases drag on for months, and that gap is exactly when a motivated seller would list. A pending violation isn't a physical defect an inspector can find. It's a legal status sitting in the locality's enforcement file, known to the owner because a notice arrived in her mailbox, invisible to anyone just examining the walls. That's the line that separates this disclosure from the general one. A failing roof invites inspection, but a pending citation only the seller can reveal. Question 35. A listing agreement on a house in Harrisonburg has not sold, and both the seller and the broker agree in writing to end the arrangement 2 months before its stated expiration. Which of the following describes that termination? Your options are A. Abandonment of the agency by the broker, B. Termination by mutual agreement, C. Revocation for cause by the client, D. Operation of law upon destruction. Before I reveal it, which one do you think is right? The correct answer is B. Termination by mutual agreement. B is correct because mutual agreement is one of the recognized ways a brokerage relationship ends, alongside completion of performance, expiration, default by either party, and the statutory dual representation conditions. A is wrong because abandonment describes an agent who simply stops working without notice or consent. Both parties here agreed, which is the opposite of one side walking away, so it cannot carry the weight placed on it. C is wrong because revocation for cause implies a breach that justified ending the relationship unilaterally. Nothing suggests the broker did anything wrong, and the seller did not act alone, and the correct answer accounts for what this misses. D is wrong because termination by operation of law follows events such as death, bankruptcy, or destruction of the property. A negotiated release is a voluntary act rather than a legal consequence. Ending a brokerage relationship is easy. Naming correctly how it ended is what determines whether anyone owes anyone else money, because the labels are not interchangeable. There are 6 recognized routes out. Performance completes the engagement, the stated term expires, the parties agree to end it early, either party defaults, statutory conditions on dual representation apply, or operation of law ends things on events nobody chose. Mutual agreement sits in the middle of that list and is the cleanest of the group. But a bare cancellation leaves the most litigated question open, whether the broker keeps a claim on prospects she introduced. A well-drafted release also handles advertising removal, sign retrieval, lockbox return, and any deposit the firm holds. Abandonment is an agent walking away unilaterally, breaching the agreement while the client still expects performance. Revocation for cause is the client ending things because of the licensee's breach, a justified response rather than a mutual decision. Operation of law needs no human decision at all. Death, bankruptcy, or destruction of the property ends it by legal consequence. A principal can generally revoke an agency at any time, even without cause, because the law won't force anyone to keep an unwanted agent. But having the power to end it is not the same as having the right, and that gap is where a great deal of agency law lives. Question 36. A Virginia licensee is found to have violated a board regulation, and the board is considering a monetary penalty in addition to other sanctions. Getting this wrong would be costly for at least one party. Which of the following states the ceiling on that penalty for each violation? Your options are A. $1,000, B. $2,000, C. $2,500, D. $5,000. What's your answer? Commit to one before I continue. The correct answer is C. $2,500. C is correct because a regulatory board within the department may impose a monetary penalty not exceeding $2,500 for each violation, and no delegation of authority may exceed that figure either. A is wrong because $1,000 is the ceiling on a cease and desist civil penalty for unlicensed activity, measured against the compensation received and taking the greater of the two. B is wrong because $2,000 appears nowhere in the licensing statutes. It reads plausibly because it sits between two figures that do appear, which is what makes it useful as a distractor. D is wrong because $5,000 is the maximum civil penalty per violation the department may recover for unlawful acts, subject to an annual cap per entity. That is a different enforcement track. Discipline against a Virginia licensee isn't a single penalty, but a ladder of sanctions, and a monetary fine is only one rung, layered on top of the others rather than replacing them. The board may reprimand, place a licensee on probation, require education, suspend or revoke a license, and still add a monetary penalty. A licensee who mishandled escrow funds could face suspension, a fine, and remedial education, all from one incident. The $2,500 ceiling applies per violation, not per case, and no board can delegate authority to exceed that same figure. A licensee who failed to deposit earnest money on time across 4 transactions has committed 4 separate violations, and the penalty multiplies accordingly. 3 real figures cluster here. $1,000 per transaction for cease and desist order against unlicensed activity. $2,500 per violation for board discipline against a licensee, and $5,000 per violation for department civil actions against any person. $2,000 appears nowhere, sitting as a trap between the real numbers. Memorizing a single figure in isolation is fragile under exam pressure, but knowing where each number sits relative to the others makes the right answer recoverable, even when recall falters. Question 37. A homeowner in Hampton wants to sell her house and have the buyer simply take over her existing loan payments without the lender's approval. The right answer turns on how the rule is actually written. Which of the following clause stands in her way? Your options are A, the escalation clause, B, the alienation clause, C, the habendum clause, D, the defeasance clause. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is B, the alienation clause. B is correct because an alienation clause, often called a due on sale clause, lets the lender call the entire balance due when the property is transferred. It prevents an unapproved buyer from stepping into the loan. A is wrong because an escalation clause in a purchase offer raises a buyer's price to beat competing offers. The term belongs to contract negotiation rather than to loan documents, which the scenario itself rules out. C is wrong because the habendum clause in a deed defines the extent of the estate being conveyed, beginning with the words to have and to hold. It has nothing to do with financing. D is wrong because a defeasance clause obligates the lender to release the lien once the debt is satisfied. It operates when the loan is paid rather than when the property changes hands. A below-market loan is valuable to a borrower, but that value can threaten a lender who never approved the new person holding it. The alienation clause exists to stop that value from being quietly transferred away. 2 distinct harms explain its reach. Credit risk means the lender underwrote one borrower, not the new one taking over. Yield risk means an old low rate keeps earning less than the market rate. When rates fall, only credit risk matters. When rates rise, lenders enforce far more routinely. The clause sits inside the deed of trust itself, and in Virginia, its consequence is direct. Acceleration is the step that precedes a trustee's exercise of the power of sale. So an unapproved transfer can put the property on a foreclosure track. Federal law carves out exceptions no lender can override. Transfers into a living trust, transfers to a surviving spouse or child, transfers incident to divorce, and junior liens that don't transfer occupancy. Outside these, taking title subject to an existing loan still triggers the clause, and the seller stays personally liable if the buyer stops paying. Remember, the lookalikes come from different documents entirely. Escalation raises a purchase price. A habendum clause defines the estate conveyed, and a defeasance clause releases the lien once paid when a stem mentions a sale, transfer, or unapproved assumption paired with a demand for the balance. It's pointing to the alienation clause. Question 38. A salesperson in Fairfax County wants her commissions paid to a limited liability company she owns rather than to herself individually. The correct label is what determines the rights of the parties. Which of the following describes what Virginia requires before that is permissible? Your options are A. A business entity salesperson license. B. A firm license issued to the company. C. Written consent from the principal broker only. D. Registration of the company with the board. Which would you go with? Lock it in before the reveal. The correct answer is A. A business entity salesperson license. A is correct because Virginia issues a business entity salesperson license where all owners and officers actively participating hold appropriate licenses. The same credentials what a real estate team must obtain. B is wrong because a firm license authorizes a business entity to act as a real estate firm, and its managing members and officers must hold broker licenses. A salesperson could not satisfy that requirement. C is wrong because the principal broker's approval matters for concurrent licensure and for transfers. It cannot create a licensed entity where the board has issued no license, so it resolves nothing for these parties. D is wrong because registration is how a company organizes under corporate law with the State Corporation Commission. The real estate board licenses rather than registers these entities, and it overlooks the operative language. Can commissions be paid to a company instead of to the salesperson herself? Virginia's license law says only a licensee can be paid for brokerage services, so the entity needs its own credential first. The baseline rule keeps the money trail visible. A client pays the firm pays the licensee, and a salesperson may accept compensation only from her principal broker. That prohibition runs both ways, so a broker can never pay someone who isn't licensed. Forming the LLC only means the State Corporation Commission confirms it exists under corporate law. Real authority to be paid comes from a separate step. The real estate board issuing a business entity salesperson license, granted when every owner and officer active in brokerage is properly licensed. This is easy to confuse with a firm license, which lets an entity hold listings, employ licensees, and supervise practice. But its managing officers must hold broker licenses, not salesperson licenses. A salesperson's LLC can never qualify for that one. Broker approval and commission registration feel like progress, but neither one substitutes for the board's license. Until the entity itself is licensed, it is legally invisible for payment purposes. Question 39. A brokerage classifies its salespersons as independent contractors and asks what the arrangement means for how the firm may direct their work. The result would be quite different under the neighboring rule. Which of the following best describes the practical distinction? Your options are A. The firm must withhold income taxes regardless. B. The firm may not supervise them. C. Licensees owe no duties to the brokerage. D. Firm controls results rather than daily methods. Don't overthink it. Which one feels right? The correct answer is D. Firm controls results rather than daily methods. D is correct because an independent contractor is engaged for results and controls her own schedule and methods, while an employee works under the employer's direction. Virginia adds that the brokerage agreement must state which status applies. A is wrong because withholding is the hallmark of employment rather than of contractor status. The classification affects tax treatment precisely because the two are handled differently, which the scenario itself rules out. B is wrong because supervision is a statutory duty a supervising broker cannot contract away, covering escrow, advertising, agency, and fair housing among other subjects. Classification never removes it, so it fails on the facts as given. C is wrong because independent contractors owe the firm everything the agreement and the license law require, including compliance with the broker's written policies and the prohibition on outside compensation, and that alone disposes of the option. Independent contractor status is often mistaken for a shield against supervision, but that mixes up two completely different kinds of control, and separating them is the key to this concept. The classification is about the manner of work. A contractor controls her own schedule, methods, and business approach, and funds her own taxes and coverage. An employee works under assigned hours and procedures, with the employer withholding taxes and providing benefits. Virginia also requires the brokerage agreement to state which status applies in writing. What classification never touches is supervision imposed by license law. A broker's duty to supervise is statutory, owed to the public and the board, covering escrow handling, advertising, agency disclosure, fair housing compliance, and transaction documentation. That duty cannot be contracted away. License law supervision controls compliance, not method. The broker sets policies, reviews advertising, and audits escrow, but doesn't dictate hours or how many open houses to hold. Meanwhile, the licensee still must follow written policies, deliver documents, and take pay only through her broker. A firm that stops supervising because licensees are contractors hasn't reduced its exposure. It has created a supervision failure charged against the broker, regardless of classification. Question 40. A seller in Suffolk is being sued over a boundary dispute, and a notice of that pending action has been filed in the land records against her property. A wrong answer here would surface again at the closing table. Which of the following describes her disclosure duty? Your options are: A. Required disclosure covers a pending list pendens. B. Recording the notice satisfies the disclosure. C. Disclosure only to cash purchases. D. General statement disclaims any representation about it. Got a guess? Lock it in. The correct answer is A. Required disclosure covers a pending list pendens. A is correct because the chapter includes a required disclosure addressing a list pendens on the property. It sits alongside the pending violations disclosure as an obligation independent of the general statement. B is wrong because recording gives constructive notice and protects the plaintiff's claim. Virginia added an affirmative disclosure because purchasers do not read the land records before writing an offer, which is why the distinction is worth memorizing. C is wrong because financing has no bearing on the duty. A lender's title examination might catch the notice, but the disclosure runs to the purchaser regardless of how she is paying. D is wrong because the general statement is aimed at physical and locational conditions the buyer should investigate. A pending lawsuit clouding title is a legal fact the owner knows and must disclose. A list pendens is a recorded notice that a lawsuit affecting title to real property is pending. Recording it accomplishes exactly one thing, and understanding that one thing explains why a separate disclosure duty had to exist. A list pendens is not a lien, since it secures no debt. It is not an adjudication, since it says nothing about who will win. It is not permanent, since it gets released when the case ends. And it does not legally stop a sale, though in practice no insurer or lender will touch a clouded title. Recording the notice creates constructive notice. Anyone who acquires the property afterward takes it subject to whatever the court decides. Without that mechanism, a seller could transfer the property to an unsuspecting buyer, and the plaintiff would win a lawsuit over property she can no longer reach. Nobody searches land records before writing an offer. A buyer tours a house Saturday, writes an offer Sunday, and doesn't learn what the title search found until weeks later, after inspections and appraisals are already paid for. Recording protects the plaintiff in the lawsuit. Disclosure protects the purchaser, because constructive notice was never a delivery mechanism for actual information. Financing doesn't change the due either. A finance buyer might accidentally catch the notice through the lender's title work, but a cash buyer has no such backup, making disclosure even more essential for them. Question 41. A buyer discovers that the seller of a Charlottesville property misrepresented a material fact and asks to be returned to the position she occupied before signing. The classification drives what happens next in the transaction. Which of the following remedy is she seeking? Your options are A. Reformation of the contract. B. Specific performance of the contract. C. Rescission of the contract. D. An assignment of the contract. Which one is it? Pause the video if you need more time. The correct answer is C. Rescission of the contract. C is correct because rescission cancels the contract and restores the parties to their pre-contract positions with the deposit returned. It is the natural remedy when consent was obtained through a material misrepresentation. A is wrong because reformation rewrites a document that failed to capture what the parties actually agreed. The problem here is the agreement itself rather than an error in transcription, which is a different problem with a different fix. B is wrong because specific performance forces completion of the sale, which is the last thing a buyer misled about a material fact would want. It presumes the buyer still wants the property. D is wrong because assignment transfers the buyer's rights to someone else and leaves the contract alive. It does nothing about a misrepresentation and may leave the original buyer secondarily liable, so it fails on the facts as given. When a real estate contract goes wrong, the injured party is really asking one question: what do you want to be holding when this is over? The answer sorts every remedy into its proper box. There are 4 possible goals: rescission, which cancels the deal; damages, which cover the cost of the breach; specific performance, which forces the sale to close; and reformation, which corrects a document that doesn't match what was actually agreed. Rescission cancels the contract and restores both sides to their pre-contract positions, deposit returned, everything unwound. It rests on a common thread: material misrepresentation, fraud, mutual mistake, duress, undue influence, and incapacity all show that consent itself was never properly obtained. Restoration runs both directions, which is what separates rescission from a simple refund. The buyer gets her money back and returns what she received, and courts adjust for any benefit taken along the way, so the goal is a reset, not a punishment. Because these contracts are voidable, the misled party must choose rescind or affirm and sue for damages, but never both. Continuing to perform or delaying after learning the truth can waive rescission entirely, so the law rewards prompt, unambiguous action. Question 40. A broker in Richmond enters her seller's listing into a common source information company so that other firms can show the property. A buyer's agent asks whether that participation creates any relationship. The outcome depends entirely on which category this falls into. Which of the following applies? Your options are A. Database use creates no relationship. B. Participation creates a relationship with cooperating firms. C. Participation creates a sub-agency relationship. D. A relationship with every registered buyer. Take a second. Which answer would you pick? The correct answer is A. Database use creates no relationship. A is correct because Virginia provides that a brokerage relationship is not created by the use of a common source information company. Membership and data sharing are marketing arrangements rather than engagements by a client. B is wrong because cooperating firms have their own clients and their own brokerage agreements. Sharing a listing gives them information and compensation arrangements rather than duties to the listing client, and no reading of the facts gets there. C is wrong because blanket subagency was once the default in many markets, and Virginia settled the question by statute. Nothing about entering data into a shared database appoints anyone to act for the seller. D is wrong because buyers who search a database have engaged nobody. Virginia creates client status only through a written brokerage agreement with a licensee, and it would produce the wrong result. In Virginia, the multiple listing service is officially called a common source information company, but its most important legal feature is what it does not do. Under the old system, entering a listing carried an implicit offer of subagency, so a cooperating broker who accepted compensation became the seller's subagent. Virginia's statute overturned this. Database participation is now purely marketing and compensation, and it appoints no one to represent anyone. Picture the database as a pipeline carrying only two things: property data and a compensation offer. A cooperating broker who taps into that pipeline represents her own client under her own agreement, with no fiduciary thread running back to the seller. The rule cuts both ways. A buyer who browses listing, saves properties, or registers on a portal has not engaged any licensee, and client status in Virginia is created only by a signed brokerage agreement. Data sharing, cooperation, and compensation offers are all beside the point. When you see a shared listing or a buyer who assumes someone represents her, look for the signed agreement. That's the only thing that matters. Question 43. A survey of a lot in Winchester reveals that the neighbor's garage extends 2 feet across the boundary line and has stood there for several years. The correct rule matters more than the customary practice does. Which of the following describes that condition? Your options are A. A license granted to the neighbor. B. An encroachment on the surveyed lot. C. An easement by necessity. D. A party wall arrangement. Before I reveal it, which one do you think is right? The correct answer is B. An encroachment on the surveyed lot. B is correct because an encroachment is an unauthorized intrusion of a building or improvement onto adjoining land. It can cloud title, and if it stands long enough without objection, may ripen into a prescriptive claim. A is wrong because a license is permission the owner gave and may revoke at will. Nothing here suggests the owner ever agreed to let the garage cross the line, so it misplaces the burden entirely. C is wrong because an easement by necessity arises where a parcel would otherwise be landlocked and depends on a common ownership history. A garage is a convenience rather than a necessity of access. D is wrong because a party wall is a shared structure straddling a boundary by agreement, common in row houses. A garage built entirely by one owner and spilling over is a different matter. When a survey shows a structure crossing a boundary line, the law calls it an encroachment, and it creates a legal problem for both owners, not just one. An encroachment is any unauthorized intrusion of a building or improvement onto a neighbor's land, and it can reach airspace as well as ground, like an overhanging eave, a bay window, or tree limbs. The defining element is always the same. Nobody authorized it and nothing was recorded. Picture 2 lots side by side. The true boundary runs in one place, but the fence sits a few feet off, and the neighbor's garage was built right up to that fence line. The garage now physically occupies land the surveyed owner holds title to. This cuts both ways. The owner's title is clouded because part of her land is occupied by a structure she doesn't control, and the neighbor's title is clouded too, because part of his garage sits on land he doesn't own, making it harder for him to sell or finance. The real danger isn't the 2 feet, it's the years of silence, continuous, Open possession can ripen into adverse possession or a prescriptive easement. So, a simple written license acknowledging permission is often the cheapest way to stop that clock. Question 44. A contractor preparing to excavate in Albemarle County counts the waiting period after submitting a locate request and is unsure which days count. The transaction cannot sensibly move ahead until this is resolved. Which of the following describes what the Act means by a working day? Your options are A. Every day except weekends and holidays. B. Monday through Friday including all holidays. C. Any day the notification center is staffed. D. Any 24-hour period after the request. What's your answer? Commit to one before I continue. The correct answer is A. Every day except weekends and holidays. A is correct because the Act defines a working day as every day except Saturdays, Sundays, and legal state and national holidays. The definition matters because both the waiting period and the notice validity are measured that way. B is wrong because including holidays would put excavators at risk on days when utility crews are not marking lines. Virginia excludes them precisely because the marks would not be there, and the scenario gives no footing for it. C is wrong because staffing at the center governs when a request can be logged and transmitted, and the center transmits notices to member operators within an hour. It does not define the counting rule. D is wrong because calendar counting would run the waiting period through weekends when nothing happens on the ground. The statute also fixes the start at a set morning hour rather than the moment of the call. Before any shovel hits the ground in Virginia, a clock starts ticking, and how you count that clock can be the difference between a safe dig and a ruptured gas line. A working day is every day except Saturdays, Sundays, and legal holidays. That single definition does double duty. It measures how long an excavator must wait to dig, and it measures how long a locate notice stays valid before it goes stale. Here's why the clock matters. A locate request goes to the notification center, which alerts utility operators, who then physically mark buried lines with paint and flags. Only after the marks are down and the waiting period passes is it safe to dig. Excluding weekends and holidays isn't red tape for its own sake. Locating crews don't work those days, so counting them would let an excavator dig on a day when nobody could have marked anything, defeating the entire purpose of waiting. Anchoring the count to a set morning hour and skipping weekends and holidays keeps the waiting period tied to real working time on the ground, not just hours on a calendar. Get that definition wrong and you either dig too early or dig on marks that no longer reflect reality. Question 45. Two lenders quote a borrower in Newport News the same interest rate, but one requires payment of 2 points at closing. The borrower asks what she is buying with that money. Which of the following describes the effect? Your options are A. Points lower the lender's yield. B. Points shorten the amortization schedule automatically. C. Points substitute for a down payment requirement. D. Points increase the lender's yield. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is D. Points increase the lender's yield. D is correct because points are prepaid interest collected at closing, which raises the lender's yield above the stated note rate. That is why a loan quoted with points carries a lower rate than one quoted without. A is wrong because the yield moves the other way. Collecting money upfront on a loan of a fixed size means the lender earns more than the note rate alone suggests. B is wrong because amortization follows the rate and the term written into the note. Paying points at closing does not shorten anything unless the borrower separately reduces the principal, and the wording of the rule forecloses it. C is wrong because a down payment reduces the amount borrowed and is the buyer's equity in the property. Points are a fee paid to the lender and leave the loan amount unchanged. Two quotes, same rate, but one adds points at closing. To judge them correctly, you need to know exactly what a point is and which way it moves the lender's return. A point is 1% of the loan amount paid up front. Discount points are prepaid interest the borrower pays now for a lower rate later, since the lender is roughly indifferent between getting paid up front or over time. Origination points, by contrast, just pay for making the loan and don't touch the rate at all. Here is the core mechanism. When the lender collects points at closing, it advances less money on a net basis while collecting the same payments. So even though the borrower's rate went down, the lender's actual yield goes up, not down. Rate and yield are two separate measures, and points are what pulls them apart. The wrong answers each fail for a specific reason. Points cannot lower the lender's yield since the money flow proves the opposite. They don't shorten amortization because that's fixed by rate and term, not by cash paid at closing. And they're not a substitute for a down payment, since a down payment builds the buyer's equity while points are simply a fee to the lender. For the borrower, it comes down to a break-even calculation. Divide the upfront cost by the monthly savings to find how long it takes to pay off, and hold long enough to profit. But the one fact to lock in is this: points always push the lender's yield up, never down. Question 46. A complaint alleges that a Virginia salesperson steered buyers away from a neighborhood because of their national origin. The complainant wants the license revoked. A licensee who guesses here creates a problem for the client. Which of the following describes which body may act on the license? Your options are A. Either board at the complainant's election. B. The Fair Housing Board alone. C. The Real Estate Board alone. D. The Attorney General on referral. Which would you go with? Lock it in before the reveal. The correct answer is C. The Real Estate Board alone. C is correct because both boards may receive complaints, investigate, and attempt conciliation, but only the Real Estate Board may initiate proceedings to revoke, suspend, or refuse to renew a real estate license. A is wrong because election by the complainant would let the choice of forum decide what remedies exist. Virginia assigns license authority by statute rather than by the complainant's preference, so it is close enough to be dangerous. B is wrong because the Fair Housing Board administers fair housing law broadly and lacks jurisdiction over real estate licensees. That division is the entire point of having two boards at one department. D is wrong because the Attorney General brings civil actions on a charge referred by a board and can obtain damages and injunctive relief. Licenses are not within that office's remedial toolkit. When a real estate licensee is accused of discrimination, two different boards can receive the complaint. That overlap is deliberate, but only one of them can ever touch the license. The Fair Housing Board covers discrimination across all of housing, from landlords to lenders. The Real Estate Board covers only its own licensees. Both can investigate and attempt conciliation, but only the Real Estate Board can revoke, suspend, or refuse to renew a license because it is the body that issued it. A board cannot revoke a license it never granted, no matter how much authority it has over the underlying conduct. And the complainant does not get to pick the forum, because that would let the choice of filing determine whether a license survives. Steering is one of the hardest violations to catch because it often happens through omission. An agent who shows a family 3 neighborhoods and quietly leaves out a 4th has steered, with no explicit statement and no completed sale required. One incident can trigger a Fair Housing Board complaint, a Real Estate Board case, and a civil action all at once, but only the licensing board can touch the license itself. Question 4-7. A seller who will be overseas at settlement signs a document authorizing her brother to execute the deed on her behalf. Her agent is asked what that document creates and what the brother becomes. Which of the following is correct? Your options are A listing agreement creating a special agent. B, power of attorney in fact. C, a brokerage agreement creating a standard agent. D, a trust agreement creating a trustee. Don't overthink it. Which one feels right? The correct answer is B. Power of attorney in fact. B is correct because a power of attorney is a written authorization to act for another, and the person it appoints is an attorney, in fact. The scope of authority is limited to what the document grants. A is wrong because a listing agreement engages a broker to market property for a commission. It authorizes marketing and negotiation rather than signing a deed in the owner's place, so the label attaches to something else. C is wrong because a brokerage agreement in Virginia creates a client relationship with a licensee. The brother is not being engaged to provide brokerage services and need not be licensed, and nothing in this scenario points that way. D is wrong because a trustee holds legal title for the benefit of another under a trust instrument. An attorney, in fact, holds no title and merely acts in the principal's name. When a seller can't be at settlement in person, the law provides a way for someone else to sign for her. That document is called a power of attorney, and its terminology shows up constantly on exams. The person granting authority is the principal, and the person appointed to act for her is called the attorney, in fact, despite the name. This has nothing to do with being a lawyer. It simply means someone appointed to act on another's behalf. These instruments differ by scope and duration. A general power covers broad authority. A limited or special power covers one stated act like signing a single deed. A durable power survives incapacity. And a springing power only activates upon a stated event. When real property is involved, the power of attorney itself gets acknowledged and recorded in the same land, records as the deed. That way, anyone examining the chain of title later can see exactly what authority backed the signature. Authority ends by revocation, expiration, completion of the task, incapacity if the power isn't durable, or death. Death terminates authority instantly and automatically, even if the attorney in fact doesn't yet know, which is why agents always confirm the principal is still living before closing. Question 48. A property manager reviewing federal law wants to confirm which characteristics the Federal Fair Housing Act names in its own text. The consequence follows entirely from which rule applies. Which of the following appears on that federal list? Your options are A, source of funds, B, military status, C, elderliness, D, familial status. Got a guess? Lock it in. The correct answer is D, familial status. D is correct because the federal statute names race, color, religion, national origin, sex, familial status, and handicap. Familial status protects households with children under 18 and pregnant women, which is where candidates most often slip. A is wrong because source of funds protects voucher holders and other lawful income sources and is a Virginia addition. Federal law leaves landlords free to refuse subsidy programs, and it would not change anyone's obligations. B is wrong because military status covers service members, veterans, and dependents under Virginia law. It appears nowhere in the federal statute's own list of protected characteristics, which is a common but costly substitution. C is wrong because elderliness is Virginia's term for persons who have reached 55. Federal law addresses older residents only through the Housing for Older Persons exemption, and the better answer lies elsewhere. Virginia protects more housing categories than federal law does, and exam questions live in that gap between the two lists. The federal statute names race, color, religion, national origin, sex, familial status, and handicap. It has a patchwork quality because it was patched together. The original 1968 Act, sex added in 1974, and familial status with handicap arriving in 1988. Familial status protects households with children under 18, pregnant women, and people obtaining legal custody, responding to a history of adults. Owner buildings and families steered away from certain units. Age itself is not a federal protected class. Federal law only carves out an exemption letting some communities restrict occupancy by age. Virginia goes further, adding source of funds, military status, and elderliness at 55 as protections federal law does not offer. When a question asks what federal law names, only the original 7 count. When it asks about Virginia, source of funds, military status, and elderliness join the list. Knowing which source governs which fact is the whole skill being tested. Question 49. A Virginia licensee markets properties under a reduced service package in which she performs only a few of the standard agent duties. Her broker asks how that arrangement affects her advertising. The rule and the customary practice are not the same thing. Which of the following applies? Your options are: advertising requires prior board approval. B. Such arrangements may not be advertised. C. Advertising must carry the limited service disclosure. D. Only the firm name is required. Which one is it? Pause the video if you need more time. The correct answer is C. Advertising must carry the limited service disclosure. C is correct because the advertising regulation requires compliance with the limited service agent disclosure requirements. A consumer seeing the advertisement should understand what the licensee will and will not do. A is wrong because the board audits compliance and disciplines violations rather than clearing individual advertisements. Prior approval appears nowhere in the advertising regulation, which is why the two are easy to mix up. B is wrong because banning the advertising would make the service impossible to offer. Virginia regulates how the arrangement is presented rather than whether it may exist at all, which leaves the situation unaddressed. D is wrong because the firm name and office contact information are required in every advertisement. A limited service arrangement adds a further disclosure obligation on top of that baseline, so the label attaches to something else. Virginia allows licensees to perform only some standard duties for a reduced fee, but it tightly regulates how that limited arrangement is presented to consumers. The brokerage agreement must conspicuously identify which duties the licensee will handle and which she won't, so the seller knows upfront that no one will attend showings or negotiate on her behalf. Advertising must carry that same disclosure, so a consumer never meets the marketing before understanding the limits. Rather than banning limited service arrangements, Virginia requires that the limitation be stated plainly and early, so sellers who want a discount package can choose it, while sellers expecting full representation are warned in time. Prior board approval would mean reviewing every sign and post across the state, an impossible volume, so enforcement happens by audit and complaint instead. Banning the advertising would quietly ban the arrangement itself, and firm name identification alone misses the point. Disclosure is the actual requirement. When a STEM describes a reduced service package or flat fee arrangement and asks about advertising, the answer is disclosure, not prior approval, not a ban, and not a bare firm name. Question 50. A locality in Virginia adopts an ordinance limiting how close a house may be built to the street and imposes no payment on affected owners. The answer decides how the file is handled from here. Which of the following government power does that ordinance rest on? Your options are A. Escheat, B. Eminent domain, C. The power of taxation, D. Police power. Take a second. Which answer would you pick? The correct answer is D. Police power. D is correct because police power is the authority to regulate for public health, safety, morals, and general welfare. Zoning setbacks restrict use without acquiring any interest, so no compensation is owed. A is wrong, because escheat returns property to the state where an owner dies leaving no heirs and no will. It transfers ownership rather than regulating how land may be used, and the analysis has to start somewhere else. B is wrong because eminent domain takes an interest in property for public use and requires just compensation. A setback line takes nothing and pays nothing, so the reasoning breaks down at the first step. C is wrong because taxation raises revenue and creates a lien if unpaid. A setback ordinance collects no money and exists to shape development patterns instead, and it would not change anyone's obligations. A setback line forces a structure to sit back from a street or property line, and the reasons stack up: light and air, sight lines, room for sidewalks and utilities, fire separation, drainage, and a consistent streetscape. The owner still owns every inch inside the setback. She holds title, pays taxes, may landscape or fence portions of it, and typically counts it toward her lot area. She simply may not build a principal structure there, and nothing changes hands, so no compensation is owed. This power to regulate without paying is called police power, the government's authority to protect health, safety, morals, and general welfare. It underlies zoning ordinances, subdivision regulations, building and housing codes, environmental controls, and licensing schemes alike. Zoning relief comes two ways. A variance excuses a dimensional standard when the property itself creates a hardship. Like an odd lot shape, a special use permit allows a use the ordinance already contemplates, but only after case-by-case review. Compare the four sovereign powers. Eminent domain takes an interest and pays for it. Taxation collects revenue. Escheat transfers ownership when heirs are absent. But police power, like a setback, restricts use and pays nothing. That single distinction is the entire concept. That's a wrap on today's full mixed practice set. Whenever you're ready to challenge yourself further, visit our website using the link in the description below. There you'll find hundreds of free practice questions along with complete, detailed study guides. Everything's designed to help you prepare thoroughly, sharpen your skills, and truly test how much you've learned so far. Hit subscribe for our next round of questions, and good luck on your Virginia Real Estate Salesperson exam.